you're primarily responsible for the SOX.
If you hold on a moment,
Are you not?
and I note that they, both the committee as well as a number of people have made a mistake in flip-flopping the board director names. So on the board of Delta, there are, including the CEO, there are 9. And on the board of Araring, there are, again, including the CEO, 9. From each of those boards, 4 resigned.
Mrs. Keneally, we've taken note of your concern about the retention values, and Mr. Roozendaal has indicated that the retention values on reserve for the bundles were met. Can I ask you whether the retention value for Delta West was actually met, and whether the retention value for the Araring Gen Trader was met?
I'm going to ask Dr. Gellatly to answer those questions.
As the Treasurer explained, the retention values were met for the packages of the 2 transactions, and it's not appropriate to disclose the individual asset retention values while there's a live transaction occurring.
Who determined the retention values?
Okay.
Who determined the retention values?
There was a process, there was a working party, one of the many, as the Treasurer mentioned before, set up, was chaired by Richard Timms of the Treasury, and that went through a process using modelling, using advisors as necessary to determine the retention values that eventually were signed off through the steering committee.
So the steering committee, which was charged to sell the assets, decided on the price?
That's the usual process in any assets are.
And was there an individual amount determined for each of the businesses?
Yes.
There was. And those amounts would have been given to the boards?
No.
They weren't given to the boards?
No.
So the boards weren't actually told what the retention value was for the assets that you were selling?
That's right.
Insisting they sell?
That's right.
They were just told to take it or leave it?
It's the usual process. You don't disclose to the boards of the corporation you're selling what the retention value is.
It's the usual process?
Yes.
We might have some other alternative evidence on that.
We might have your questions now. John, if you're ready to go with your questions?
I'm ready to go, Chair.
Then we'll break for morning tea after you've finished.
So 10 minutes. Yeah. Premier, just to the issue that was exercised by Mr. Khan in respect of your motivation in proroguing Parliament, you've made it clear to the committee that it was not about avoiding scrutiny by this committee. Is that correct? Can I summarise your position as saying you had no intention of avoiding scrutiny? It was on your heart or your mind to avoid scrutiny when you prorogued Parliament?
No.
Thank you. So how do you gel with the following statement made by the Treasurer to the Daily Telegraph, to Gemma Jones at the Daily Telegraph, on the following day, where he said any scrutiny should not be done by a politically motivated committee? Some of the present members of the committee have already said publicly and in Hansard they object to the transaction. It's been prorogued early, it's been prorogued later, before past elections, but at the end of the day we've got to work in the interest of the people of New South Wales. Do you read that statement as saying that his belief that it was that the prorogation happened specifically in order to avoid before the schedule?
No, I don't see that with the greatest of respect, Dr. Kay, in those words. The Treasurer makes the point there that he's made here today and that I've made, that we are still in a live transaction process, and our responsibility as Premier and Treasurer is to the taxpayers of New South Wales to get the best value and the best outcome, and indeed to achieve the objectives we set out in 2008 following the Owen report.
Premier, with respect, we're talking here about the prorogation, and you said your prorogation had nothing to do with avoiding scrutiny before this committee.
Indeed, I'm here
today. And the next day, the Treasurer is out there saying, well, there shouldn't be any scrutiny before this committee.
Well, I think the Treasurer, if I hear those words, and certainly he's able to speak for himself, Dr. Kay, and you may ask me a question, but if you'd like me to interpret for you the Treasurer's words, I think he makes a valid point that there are those, and it's their right to do so, to have political differences on the structure of the electricity market and the ownership of various assets or classes of assets within the electricity market. And what we would not want to see is those who have different political views seek to scuttle a live transaction that is ongoing, that is seeking to achieve the policy objectives of this government.
And you give that answer in response to the question about prorogation, or you're just making that as a general observation? Because I asked you about prorogation, you said you would not seek to have it scuttled.
You've asked me to explain my understanding of that quote you read out from the Treasurer.
Okay, let's go to the Treasurer for a minute. Treasurer, in his opening... Oh no, let's not. Let's just go back one step. And maybe the Treasurer would prefer to answer this because he might have more detailed knowledge. Is it not correct that in the confidentiality agreements that there is a specific clause that allows people who have signed the confidentiality agreement to give answers, fulsome answers, when they're required to do so by a lawful body?
In which agreements are you referring to?
In the confidentiality agreements that I presume the boards of the directors have signed with the transaction process.
I'm not aware of the what the individual confidentiality agreements are of those state-owned corporations, so I can't really comment on those.
Dr. Gellatly, are you aware of what's in those?
Not off the top of my head.
So you don't know what's in it? You've signed one of those confidentiality agreements, I presume?
As a director?
Yeah.
No.
So you signed no confidentiality agreement with respect to this process at all?
Oh, yeah, of course I did. When I I signed the confidentiality agreement as a chair of the reform process. Obviously, there's confidentiality agreement in that
When
regard.
the reform process provided information about the transaction to the boards of directors, was there a confidentiality agreement that they had to sign in respect to that?
I'm sure there was. I can't
And it would have been Mr. Yeadon's.
Yes, there was a confidentiality agreement, but I think as was indicated earlier, is that there are differences of legal opinion as to the status of this committee. No, but I would say to you, for my purposes, I'm not prepared to break confidentiality agreements in the current circumstances.
What I'd like to know is there a clause in there which says a lawfully constituted body, if you give an answer to a lawfully constituted body or are compelled to do so, then you are not bound by that confidentiality agreement?
No, I'm not sure that that actual provision was in the confidentiality agreement that I signed.
You don't recall it was in there?
Not off the top of my head.
Okay.
No, don't quote me on it. It may be there. But
I think
is it possible for a copy of that agreement to be tabled? Not the one that was signed, but a pro forma agreement, so where the committee knows exactly.
Could that be tabled today?
We'll give you our best undertaking to do so.
Thank you.
Good, thank you.
But Chairman, I would indicate again that as I indicated in my earlier answer, in that I'm very happy to come here to this committee and answer all questions. But I would like the committee to bear in mind that there is some legal question, differences of opinion, which I believe would only be resolved at the end of the day in the court itself in relation to matters of privilege and protection here in this committee meeting, and I will not go to areas that will see me breaching confidentiality or jeopardising the future prospects of this transaction, as the Treasurer and Premier have indicated are live, and that would be just simply too detrimental for the people of New South Wales. So I will not go into areas of commercial confidentiality.
Thank you, Mr. Yeadon. I appreciate that. I'd like to now go to the Treasurer and ask the Treasurer some specific questions about the actual transaction itself. You've signed memorandums of understanding to conclude GenTrader contracts with Origin and True Energy for Eraring and Delta West. Is that correct? But you haven't signed the contracts themselves.
Well, we're moving towards financial closure by the beginning of March.
By the beginning of March.
Mm-hmm.
So would that be before the 5th of March?
Yes, the transactions are scheduled to be finished. In fact, at the end of February.
And is it not true, Treasurer, that the government goes into caretaker mode on the 5th of March?
Yes.
Would you sign? Are you in a position to sign the contracts if there's a delay in moving to closure? Would you sign the contracts while you're in caretaker mode?
Well, we anticipate that the transaction will be completed on time.
Fantastic. But if it's not, because we know sometimes transactions involving these sorts of things are not, would you sign it while you're in caretaker
We'd
mode?
have to seek advice as to the appropriate behaviour of the government if we were in caretaker mode.
Will you provide this committee with that advice?
In the event that we need to, we'll seek that advice.
Thank you. Can I now ask you about, well, that's not unusual. Can I now ask you about the terms of the contract? This is a contract, there are two contracts as I understand it, and I must say there's a lot of information released by Origin Energy and very little by yourself, and that's an interesting point in of itself. But can I ask you about the arrangements with the contract? You said before that we're moving out of the risky business of generation. We're the state of New South Wales moving out of the risky business of generation. Yet there are a number of clauses within that contract, as revealed by Origin Energy in their statement to their shareholders, which suggests that there are still substantial risks, or some risks, associated with this contract left with the people of New South Wales. Is that correct?
Well, I think the simple answer to that is that what the Gen Trade Agreement does is apportion risk between the generators and the gen trader and the generation trader. The responsibilities for the generators is effectively to deliver power. They become an asset manager. Their responsibility is to deliver power, and it becomes all the market risk of trading that energy falls into the responsibility of the gen trader. The obligations of the generators...
All of the market risk?
The market risk in terms of trading.
All of the market risk in terms of trading. Okay, good.
Yes. The generators are responsible for the delivery of power. In the event that they don't deliver power, they have an obligation to compensate the gen traders. But I just want to make this point because I know exactly where you're going with this.
Oh, I'm impressed by your questions, but let me show you where I'm going with that and ask you the following question.
Yes.
When you say that the risk, there are, I guess they're referred to as ALDs, in the gen trader contract, they're called availability liquidated damages. Is it not true that those liquidated damages depend on the market price at the time of the generator outage? So this is the payment that the publicly owned generator has to make to the gen trader if the publicly owned generator fails to deliver energy at a particular time. Is it not true that those damages are dependent on market price?
I'll let Mr. Yeadon answer that.